Shall we play a game?
There appears to be some threats in this response. What does this mean? Because the judge is trying to save herself from being hung to death. Hung to death.
That's brought upon the court to you as treason against the interstate commerce and the United States Constitution. And dropped the fraud upon the court. All I stated was
I'm asking a specific question.
All I'm doing is giving the specific
You're going to answer my question, and you're going to operate with decorum and control over yourself.
I got it.
Or you see this officer back here? Okay, on the record in the matter of Corey Deshaun Blocker versus South Washington Park. This is 25-06485. Is that you, sir?
That's me. Yes, ma'am.
Come forward. Counsel appearance.
Good afternoon, Your Honor. Jeff Klug appearing on behalf of Defendants, South Washington Park.
Okay, and your name for the record, sir?
Corey Deshaun Blocker.
Okay, Mr. Blocker, as present as the plaintiff in pro per, and then Mr. Klug, you are representing South Washington Park. This was scheduled for motion for summary disposition, which the defendant filed against you, Mr. Blocker, but I don't see where you responded.
Yes, I responded by affidavit of fact.
Affidavit of fact?
Yep.
Legal title is an answer. Let's see if this is.
After the defendant has not disputed line for line.
Okay, that is not a response to a motion in brief for summary disposition. I'm looking at an administrative complaint objecting to summary disposition. Is that what you're talking about?
That is a response.
Okay, that's, well, you said you responded by affidavit.
And I got affidavit of fact in there too to respond to everything that they done to me, that he has not defended, not one line. I have affidavit of fact and an administrative complaint to respond to his complaint. So I have responded, and he has not responded back.
Mr. Blocker Corey Deshaun Blocker makes said complaint for this court record and on this court's record. Corey Deshaun Blocker makes this administrative complaint to object the summary disposition motion for January 12, 2026 for the delay tactic it is by this court. First, Kristen D. Simmons, should be Judge Kristen D. Simmons, recuse yourself as you are supposed to do by law. Second, until the defendant can respond by affidavit only, there is no need for summary disposition because this case is going to be granted by judgment by default in the tome allowed by law to be responded. The fact that the defendant cannot responded and Kristen D. Simmons was supposed to recuse herself furthermore proves the fraud upon the court that was committed and the fraud upon the court still being committed because the judge is providing an unfair advantage to try and save her from being hung to death for fraud upon the court committed by Kristen D. Simmons. Therefore, the defendant has the time given by law to respond to this case will be granted full and final judgment with no further need for litigation. That's the response you filed?
No, I got an affidavit of fact. Can you read my affidavit of fact?
We're gonna stop here because as I perceive this, and this is the response you received, Mr. Klug?
Yes, Judge, that is the response that we received.
There appears to be some threats in this response. What does this mean? Because the judge is trying to save herself from being hung to death.
That's brought upon the court to you as treason against the interstate commerce and the United States Constitution. And dropped the fraud upon the court. I stated was
I'm asking a specific question.
All I'm doing is giving the specific
You're going to answer my question, and you're going to operate with decorum and control over yourself.
I got it.
Or you see this officer back here? You see him? I will put you in custody for contempt.
On what ground?
Yell in my court and
I didn't yell at your court.
Control yourself. I'm going to ask you another question. You're going to answer my question. What does it mean when you say the judge is trying to save herself from being hung to death? Is that a threat?
No, ma'am. like I just explained. That is, if you are convicted of fraud, because I'm going to go down and file a misconduct, judicial misconduct against both y'all, because he didn't send the mail, so I could sit up here and defend against that, which is in my affidavit of fact. That's what I'm saying. My affidavit of fact that he has.
Calm down.
Okay, my affidavit of fact that he didn't defend, it states that he knew my exact address and sent it to the wrong place, so I didn't even get to the defendant until after I sent the affidavit of fact.
He knew your exact address.
He knew it exact because I sent
it what to the wrong address.
I sent to change the address, and he got it.
What did he send? What did he send to the wrong address?
He sent the whole complaint, his the motion for summary judgment. I mean, yeah, summary deposition. He sent all that to the wrong address purposely, and you can see when I sent the change of address, it's after he sends the summary deposition to the wrong address. That's judicial misconduct.
So he's not a judge, sir. So he doesn't get judicial misconduct. Okay. Did you receive?
No, I didn't. I had to come up here.
Did I ask the question yet? Did I ask the question?
All right, man.
Thank you.
I got what this is.
Do you have control over yourself?
I sure do.
Okay, well, that means you need to wait till I finish asking the question before you can answer it. And you also need to control your tone. Do you understand that? Because if I perceive your behavior to be a threat, you're going to go into custody. Do you understand that? Did you receive his motion for summary disposition?
No, ma'am.
Okay, when did you find out about it?
When I came in here to file for motion for judgment by the court.
Okay, and that's when you were notified that he had filed a motion. Okay, this looks like this was back in November. Counsel, where did you serve the motion for summary?
Your Honor, in Mr. Blocker's administrative complaint, his address listed is the Kelly Road, Mason, Michigan, 48854. That is where we serve the motion for summary disposition on. And his administrative complaint objecting to the summary disposition, he dates it December 3rd, 2025. So he filed a response that he dates December 3rd, 2025. So that's, I mean, I'm looking at this. Our motion for summary disposition was dated November 13th, 2025. And proof of service should have been, my assumption is that same day. Let me look at the proof of service here attached. Yeah, November 13th, 2025. We sent the motion for summary disposition to his address at Kelly Road, Mason, Michigan. He then filed that administrative complaint objecting to the summary disposition. He dated it December 3rd, 2025. This court then renoticed the hearing from the January, what date was that? The January date to today's date at 2 p.m. And they served a notice to Mr. Blocker at the P.O. Box 11004, 315 West Allegan Street, Lansing, Michigan. So we served him with it, the address and information we had. He filed an answer to it. I don't know how he can say that he did not receive the motion if he filed an answer, a response to it. So,
okay, so it looks like even if it was served on an address that had been changed, it looks like that was within short time frame of you sending this change of address, which I'm looking at the change of address and when it was dated for the court. Nonetheless, it looks like that issue has been cured, and you've responded to the motion. At least to what you believe is a response. I don't see where you address the statements that they made in the motion.
On my fact, can I speak?
Yes.
My affidavit of fact addresses every one of them, and that's after his response. My affidavit of fact goes through everything he stated. My affidavit of fact breaks it down line by line.
Then you're talking about the administrative complaint to change your address?
No, I'm talking about the administrative complaint. That's an affidavit of fact. I need to adjourn to get my paperwork so I can come back and do this. But I can
promise you one thing. This is going to get resolved today. There will not be an adjourning and coming back.
but I have filed a response and I filed an affidavit of fact. That affidavit of fact in there is evidence. It's proven by law. As long as I got that affidavit of fact, I defeated his motion for a summary deposition because I have the affidavit of fact in it, and that's evidence.
This is the administrative response and affidavit of fact filed December 29th, correct?
And that's evidence.
Corey Deshaun Blocker makes this administrative response and affidavit of fact for this court's record and on this court's record. Corey Deshaun Blocker makes this administrative response by affidavit of fact to respond to the defendant's motion for summary disposition under grounds Michigan Court Rule 2.116 and under MRC 2.116C10, which this affidavit of fact defeats the defendant's motion and gives the plaintiff grounds that relief must be granted. Corey Deshaun Blocker states for the record with this affidavit that on November 15th, 2023 at around 2 a.m., Corey Deshaun Blocker, resident, was broken into by Lansing Police Department for what should have been a civil complaint. That never happened because the defendant allowed the situation to escalate, even though Corey Deshaun Blocker on many occasions went to the defendant explaining the problem that neighbor Andrew Workman was causing, banging on the walls for months. The reason the defendant allowed Andrew Workman to bang on the wall was because the defendant was retaliating against Corey Deshaun Blocker for filing a lawsuit against the defendant because of repeated requests for the first month's rent and deposit, which Corey Deshaun Blocker said the computer proved. But the defendants for 3 months sent letters demanding the payment. After the lawsuit was filed, the defendant finally acknowledged payment, but then the banging on the wall by Andrew Workman began. And even though the defendant and the Lansing Police Department stated Andrew Workman was going to be evicted, Corey Deshaun Blocker is the one who was illegally incarcerated and evicted on January 15, 2024 by the defendant. Because this court never allowed Corey Blocker's appeal to proceed, that the record show he verbally requested in court. Then there is the fact that Ingham County Jail purposely held Corey Deshaun Blocker's written motion for appeal and never allowed it to reach the courts in time. Then there is the fact that Corey Deshaun Blocker's puppies were stolen out of his residence by Ingham County Animal Control with the consent of the defendant and no written consent from Corey Deshaun Blocker to enter his residence, which is illegal and makes the defendant liable for Corey Deshaun Blocker's puppies being killed and sold by the Ingham County Animal Control. Then there is the fact that Judge Carol Koenig and Cole then illegally incarcerated Corey Deshaun Blocker for child support case that was closed in 2005 when the child died. But both judges reopened the case without congressional authority to do so by law, which violates Corey Deshaun Blocker's 6th Amendment because the codes that were used violates the U.S. Constitution 14th Amendment right to due process, furthermore, giving grounds that relief can be granted. Then there is the fact that Corey Deshaun Blocker was illegally incarcerated for 4 months, which the fact that Corey Deshaun Blocker was not convicted on any charge proves that the defendant and its affiliates concocted and purposely committed treason against the United States Constitution for the purpose of denying Corey Deshaun Blocker from being made whole. Now there is the fact that this court is still committing fraud upon the court by the judge not recusing herself for conflict of interest, which was done in the case 23-028252LT, because she by law must recuse herself by law. Then there is the fact that the docket text proves that the defendant's motion was sent to the wrong address on purpose. The courts knew it was sent to the wrong address and committed fraud upon the court by allowing the motion date to be set without proper service, which furthermore proves the defendant and their affiliates' guilt beyond a shadow of a doubt, and grounds that relief must be granted by law. This affidavit was given in response for the purpose of giving evidence to defeat MCR 2.116C78 and MCR 2.116C10, which This affidavit of fact defeats both codes. Therefore, by law, the defendant has 10 days by law to respond by affidavit, only defeating line by line. Sign and notarize. Counsel, you can respond.
Your Honor, the defendant has failed to state a relief for which still play a complaint for which relief can be granted against the defendant. This all stems from the landlord-tenant eviction case that was filed in 2023. A hearing was held. My client was granted judgment in its favor. Mr. Blocker was not happy with it. He didn't follow the proper procedures to appeal that. Instead, he filed a complaint almost 2 years later against my client and alleging the same facts arising out of what the hearing already had pertaining to his eviction. The administrative complaint is attached as Exhibit 1 to my motion and to defendant's motion. And again, he doesn't allege he doesn't plead anything in which any kind of complaint can be asserted against the defendant. Instead, most of the complaint is alleged against you, Your Honor. And I find it very disturbing. I've never experienced this in my entire almost 18 years of practicing law. I don't know if you have, but in there, he demands that the judge who ruled in this case be hung to death for treason against the U.S. Constitution, 6th and 14th Amendment. I have never seen somebody make these statements about a judge. And then he also goes on and alleges you should recuse yourself from hearing this case because you heard the original landlord-tenant matter. But the fact of the matter is, Your Honor, Exhibit 1 to defendant's motion for summary disposition is the plaintiff's complaint. He has not stated any kind of relief from which he can be granted against the what defendant did. In fact, most of it is directed against the court. So at this time, I would state that that defendant's motion be granted and plaintiff's case be dismissed with prejudice. Thank you.
Thank you. Did you have anything else you
Yes,
wanted to
I want
add?
to respond because what the law states is not me doing any derogatory to the judge. The law states for treason amongst interstate commerce and treason amongst the United States Constitution, what must be done. That he's sitting up stating that what the Constitution states, that is not here nor there. The fact that I gave evidence, because I gave evidence, new evidence of what sat back, because they didn't bring no evidence of the puppies. You didn't make them bring no evidence of puppies being walked around, none of the stuff that you granted. And that the fact that you recused yourself in that first case, like I said, I got to go get the paperwork. You did recuse yourself and then came into this case and didn't recuse yourself. Like I said, no matter what, I'm going to appeal because you did recuse yourself. Sent me the letter recusing yourself. Now that you're sitting here, I don't know what he's talking about. He got the letter that you recused yourself too. You did recuse yourself. I'm not being derogative or nothing. That's a fact. You did recuse yourself in the first case. So how can you take this case on now?
Okay,
I'm done.
thank you. I'm glad that you're done, sir. Let me be clear. I distinctly remember the eviction. Mr. Blocker was in the custody of the Ingham County Jail. The court did not recuse themselves. They had no reason to recuse themselves. The court held a hearing on the eviction and the plaintiff was granted the eviction. What happened with your dogs and anything else after the fact, the court had no control over, nor did the court have any involvement. I do, however, in this case, have at least two instances where you have made filings where you mentioned that the judge, being Kristen Simmons, should be hung to death, which I take as threat. So that will be reported to the proper authorities for that purpose. As it relates to your complaint, I agree with the defendant in this case that you have not stated a claim of action upon which this court can grant you relief. Again, your complaint talks about an eviction that you had the right to appeal and did not properly file and proceed with an appeal. And then it also makes statements mostly against the judge who presided over that eviction, and claims that you believe that judge should be hung to death for the decision made in that eviction. So your request to have this case proceed cannot be granted. I have to grant the motion for summary disposition of the defense, your case is dismissed.
Okay.
Any additional matters for the record?
No, Judge, I'll prepare an order.
Thank you.
Thank you, Judge.
Now, let's go over that. Summary disposition means the court determines there is no genuine issue of material fact. Even if everything alleged were accepted as true, the law does not support the claim. And when that happens, the case ends. Blocker's demand to hang defendants and their relatives for treason is an abuse of the judicial process and demonstrates his bad faith in filing yet another frivolous complaint. The court has already addressed prior demands involving treason, and this is the language of a federal judge. And today, Judge Simmons affirmed that decision.
As a famous person once said, you can fool some of the people some of the time, but you can't fool all of the people all of the time. And as I, another more famous person, once said, if you don't teach them to read, you can fool them whenever you like.
Now, if you appreciate these trips to the courtroom, hit those emotional support buttons for YouTube. Like, subscribe, and comment. Let me know what you think. And thank you to our channel members. Your support keeps this channel focused on the record, for the record, and by the record. I appreciate you all. Summary disposition is not dramatic. It's procedural. And when there's no genuine issue of material fact, the court does not continue the argument. Belief meets procedure. Procedure wins. Till next time, I'll see you soon.